My name is Adv Allan Kibet. I'm an advocate of the High Court of Kenya, practicing particularly here in Nakuru. With me here, we have a petitioner who has filed a case against the county government of Nakuru, has filed a case against the County Assembly of Nakuru, has filed a case against the County Public Services Board, claiming that the process of interviewing, the process of nomination, and forwarding the names of the nominees to the position of the county as county chief officers was riddled with irregularities. They suffer from unconstitutionality. This here is Stephen Odwor, the petitioner. The court on the 11th of November 2022 issued orders staying approval or vetting of these nominees to the county county government officers' positions. However, we have information, credible information, that the vetting continued despite the fact that court orders had been issued against the said vetting. Only 2 people out of these said nominees remain to be vetted, and this was stopped, in our view, having the County Assembly having realized and appreciated that the National Assembly had also stopped the vetting exercise that had been scheduled to take place. What the petitioner, who is with me here, is saying is that persons with disability were not considered. There were persons with disabilities who were interviewed and who succeeded and scored highly, who were supposed to be considered. Not a single one of them was nominated by the governor for purposes of vetting and subsequently appointment. The other issue that has been raised by the petition is that persons who were interviewed and who applied and interviewed for specific dockets in the assembly were nominated to different dockets which they were not subjected to interviews. This, in the view of the petitioner, and I believe in my view, is unfair to those persons who were subjected to interviews. It is unconstitutional. It is illegal. We were today before court for directions in respect to that petition and the orders that had been issued by the court, where we took the said directions. The petitioners have today filed what we call a notice of preliminary objection, shortly termed a PO, where they are challenging the jurisdiction of this court to issue the orders that they issued, and they are seeking that the said orders be vacated. In our view, this not only involves the County Public Service Board decision on the vetting, but also the appointment, that is the nomination by the governor. So in our view, we believe that this petition is squarely and appropriately before the Employment and Labor Relations Court. This is our stand, and we have always maintained this, that court orders are not proposals, they are not recommendations, they are not invitation to choose whether to obey or not to obey. Orders must always be obeyed. Unless they are reviewed, unless they are varied, unless they are set aside. These orders remain in force, they have not been reviewed, they have not been set aside. So as it stands, the said vetting was in contempt of the court order, and we have instructions by the petitioner, who is here with me, to take the next step, and that is institute court proceedings, to have the respondents who engaged in this illegality committed to civil jail or be fined such sum of money as the court will decide in order to prevent and avert such future acts of violation of court order.